So hello everybody and welcome to the first in our season of seminars from the Centre for European Legal Studies at the University of Cambridge. I'm Kenneth Armstrong, Professor of European Law, and delighted to be chairing today's session. I know some of you are just beginning to join the webinar, so I'll give you a couple of minutes to get into the room. We are really thrilled to have as our first speaker Charlotte O'Brien, who is Professor of Law at York Law School. Charlotte will be very well known to many of you for her really pioneering socio-legal work on issues of EU citizenship rights, the project she's been working on EU Rights and Brexit Hub, working with NGOs and other organisations who are providing advice to EU nationals in the UK, and really one of the few people who are working on these issues from a socio-legal and empirical point of view, and it's a really important strand of research, and we're delighted to have Charlotte here today. Her talk today is going to be, and I hope, Charlotte, I've got the title right, it's the Great EU Citizenship Illusion Dispelled, the Evaporation of Equal Treatment for Vulnerable EU Citizens. And I know we will all look forward to learning more about this from you today. So without further ado, Charlotte, it's over to you.
Thank you so much for that lovely introduction, Kenneth, and thank you to the research unit for inviting me to speak today. As you mentioned, a lot of my work at the moment is based on a socio-legal study of the rights of EU nationals in the UK. And one issue that has been recurrent in terms of the cases that we are seeing and the cases that we are dealing with, but also is becoming increasingly prominent in the case law, so it's of doctrinal as well as socio-legal interest and importance, I hope, is the rights of people with pre-settled status. And that's been the subject of a recent CJEU case in which I am in the process of arguing that the illusion of EU citizenship, which so far has been something of an airy one to begin with anyway, is becoming increasingly dispelled. There's less of a pretense amongst the court that it means a great deal or adds anything on to rights achieved through economic activity. Now, I'm going to attempt to share the screen because I put together a PowerPoint. Let's see if this works. Thumbs up, does that work or not, Kenneth? Excellent, thank you. Right, so the Great EU Citizenship Illusion Dispelled, the Evaporation of Equal Treatment for Vulnerable EU Citizens. The vulnerability element is important because it's frequently those citizens who are least able to rely on the conventional rights who are at risk, and therefore the citizens for whom EU citizenship is potentially most important or offers the most, if illusory, promise. Now, if I go quickly on to the next slide, oops, the trend that we've seen in citizenship case law has been well documented over recent years, that we've seen the kind of the dormant phase when it was initiated or when it was incorporated into the Maastricht Treaty, and there was very little that was obviously stemming from that. It was compared to a carnet of tickets for attractions that nobody wanted to go to, described as anodyne and toothless. And then we have Martinez Sala and Triani, and cases that suddenly explode with this idea that an EU citizen can claim equal treatment by virtue of that citizenship, qua citizen, not just qua worker. And then past this progressive phase, we saw what's been described as a kind of a plateauing, and then a regressive phase, which as the term Eleanor Spaventa has famously used, to look at a series of cases in which the court appears to have reined back or reined in the ambitions that it earlier expressed with regard to EU citizenship. So we've got Bray, Darno, Ali Manovich, Garcia Nieto, and Commission in UK, the case in which it was found that the UK's requirement to have a right to reside, i.e. to fit within some of the qualifying criteria of Directive 2004/38 as implemented in the 2016, or as was issued the 2006 EEA immigration regulations, was considered lawful by the court, was at most indirect discrimination. And that was even though it applied to benefits, social security benefits that were pure social security under Regulation 883/2004. Pure social security that were not social assistance, subject to Article 24 in the directive, the CRD. So we have this kind of what's been described as a regressive phase, but is also in some ways kind of hugely expansionist, because it's expanding the remit of the directive and the restrictions of the directive, and what I have recently been calling the tyranny of the directive, whereby all primary law rights or rights in other forms of secondary law just become subjugated to the conditions of the directive. That unless you meet these conditions, you just are a persona non grata, you know, your citizenship does not count. And then we had some recent glimmers that there might be something different happening. There might be a reconsideration going on in the AG's opinion in the case of A, in which, having been told in Grzelczyk and other cases that EU citizenship was our fundamental destiny, or was destined to become the fundamental status rather, in A, we have the AG saying that the status of the citizen of the Union has become the fundamental status of nationals of the member states. So an idea that we've somehow arrived at this process, at the end of this process. And then in Crefeld, we have a judgment from the Court of Justice, which addressed questions about Texera and Ibrahim rights, derivative rights of primary carers that originate not in the directive, but in regulation, in the equal treatment for workers provisions. So Regulation 492/2011, Article 10, the regulation requiring that the children of migrant workers are entitled to reside under the best possible conditions, and that being interpreted to include a right to reside for their primary carer, a right to reside which includes a right to access benefits. And this was being queried in Crefeld, or we could be applying the restrictions of the directive for people in this situation, only allow them access to benefits if they're workers, etc. And the court was quite clear that no, the derogations in the directive are meant for people who fall in the scope of the directive. A derogation from the principle of equal treatment laid down in the first paragraph of Article 18 TFEU, of which Article 24.1 of Directive 2004/38 is merely a specific expression. Article 24.2 must be interpreted strictly and in accordance with the provisions of the treaty, including those relating to union citizenship and freedom of movement for workers. So union citizenship is suddenly coming into view as more of a fundamental principle again, or as a prism through which conditions are to be interpreted rather than the other way round. However, that was not to be, that glimmer of promise. What we've seen in the case of CG 709/20, the case involving EU citizens with pre-settled status in the UK, is a sort of a retreat back into the regressive phase, retreat back under the comforting shelter of Directive 2004/38. Now, a little bit of background as to what this case is and why it's relevant beyond just the UK. So, in order to legislate for EU citizens' rights in the UK, and of course, by the same token, UK citizens' rights in the EU, the EU and UK drew up the withdrawal agreement, which has a section all about EU citizens' rights, providing for continued residence rights for those who were, if we just focus on EU in the UK, EU nationals in the UK before the end of transition period should continue to have resident rights, but only if they fall within the scope of Directive 2004/38. Now, I've written already in the CMRF about why I feel this is a deeply, deeply problematic restriction of continuing residence rights. The fact that the directive is full of gaps, lacunae, that affect particular groups disproportionately, people with care histories punctuating their periods of work, which is disproportionately women, children who don't have any personal rights under the directive. They have only parasitic residence rights. They're entirely dependent upon the relationship, employment, and migratory choices and misfortunes of their parents. And yet, nevertheless, the directive is what has been used as the template, the blueprint for the withdrawal agreement rights, which broadly sets out rights to permanent residence, which is like permanent residence in the directive, and temporary residence, which is like the temporary residence in Article 7 of the directive. Now, the UK's EU settled status scheme, which is supposed to implement these rights, is actually more inclusive, and I suspect largely as much a matter of administrative necessity as any intended altruism. But what is required is not showing a work history of continual conformity with the directive. Rather, what is required to get settled status is just 5 years of residence. Broadly speaking, there are some exceptions in shorter periods in some circumstances. Or if you have fewer than 5 years of residence, then you're looking at pre-settled status. And again, there's no requirement to conform with the conditions of the directive. Now, given the scale of the task that the Home Office faced under the EUSS, with what we've seen is, more than 6 million applications over a relatively short period of time, it would have been completely impossible for them to actually delve into each individual work and relationship and migration history in order to try and excavate the information they'd need for each individual to find out whether they conformed with the requirements of the directive. Now, I just know that from experience of dealing with directive-related benefit claims pre-transition, pre-Brexit, that each individual one gets incredibly complicated, and there's lots of arguments to be had about what is a period of retained worker status and what isn't. And that would just have been a task far beyond what was possible in the timescale the government had set itself. So instead, what we have is a residence-based status. However, while it's more inclusive, it is a constitutive status. Now, the withdrawal agreement did not mandate a constitutive status, it made it possible. So EU residence rights typically, pre-Brexit, are declaratory, which means that you need to meet the underlying conditions. And if you meet the underlying conditions, you have a right. So, for instance, to have permanent residence under the CRD, you need to show that you have conformed with the directive for 5 years. You don't need to have the certificate. In the EU settled status scheme, that is turned on its head. It's having the status that is necessary. I'd say the certificate, but that's a whole separate issue where they don't actually issue a physical certificate. It's a digital one, and that's creating all sorts of extra problems. But it's having that digital status. If you don't have it and you didn't get it by the deadline, then that's it. Your pre-existing rights, regardless of how long you've lived and worked in the UK, how much you've contributed, it all evaporates. It all counts for nothing. Meeting the underlying conditions does not count. There's a caveat, of course, that it's possible to make late applications with reasonable grounds, but that is a possibility. It's not a right, and so on. So there are two key statuses: settled status and pre-settled status. And what emerged quite clearly as an afterthought on the part of the UK government was, what are the rights of people with pre-settled status? Because people were able to get these statuses from March 2019. And it was only in April 2019 that regulations were laid to come into force in May 2019, restricting rights to benefits for people with pre-settled status. So how do those regulations work? Well, these are the regulations. I wrote them out just so I don't have to say them. They're a mouthful. But the effect of these regulations is to categorise pre-settled status as a right to reside that does not count in terms of access to benefits. So in order to access these benefits, as well as meeting other eligibility criteria, if you're an EU national, you have to have a right to reside, but it must be one that's different to pre-settled status. So if you're pre-settled, you can get benefits, but only if you can show you're also a worker or the family member of a worker, typically. Now, these regulations have inevitably been subject to challenge, and the litigation history is relatively complex, but I'll try and make it a sort of a potted, simplified version. So in the case of Flotilla, these regulations were challenged on the grounds that people with pre-settled status have a right to reside. And while all the case law hitherto demonstrated it was okay for member states to require a right to reside, it's a different thing to say, but not that right to reside. That what you're doing there is, while we can describe requiring a right to reside as indirect nationality discrimination, actually, as soon as you say, well, if it's a domestically awarded right to reside, which is what UK nationals have, but it's not the domestically awarded right to reside that UK nationals have, it's a different domestically awarded right to reside that's only awarded to EU nationals and their family members, then that's nationality discrimination, and it's direct. And it contravenes the ratio in Triani. In Triani, the court had found that once a member state had granted a right to reside to somebody, to an EU national, an EU migrant, that person was entitled to protection from discrimination, was entitled to rely on primary law-based equal treatment rights. Now, the way a number of member states get around the Triani ruling is simply not awarding a right to reside, and therefore they can say when you try and claim a right to reside, you're relying purely on EU law, therefore you have to meet the conditions of EU law, as in Dano. You have to meet 2004-38 conditions, and if you don't have a right to reside, you don't have entitlement to benefits. But what we have here is a really interesting and novel situation where the UK is effectively recreating the Triani situation. There is a domestic right to reside that has been awarded. Now, the DWP's response in Flotilla was essentially, well, we just wanted people to have the same rights after having pre-settled status as they did before they got pre-settled status. And if pre-settled status did trigger all these extra rights, which it was kind of agreed that it did, which is why they had to introduce these regulations in the first place, that was an unintended consequence. Now, the argument of the claimants was essentially unintended or not, it's a legal consequence. You create this status, you invest this status with quite a lot of significance by deciding it's a constitutive status. You have to face up to the fact that you've created further entitlements, and these regulations contravene the ruling in Triani. And the Court of Appeal of England and Wales agreed with the claimants, which was something of a shocker, given the UK court's history with tangoing with EU citizenship-based claims. But they found it fairly straightforward and fairly clear that Triani had not been at any point overruled by the CJEU, therefore it was still good law. And if it was still good law, then the claimants had to win. They had a right to reside and they were entitled to protection from Article 18 TFEU, bearing in mind that this, as with the CG case, the case facts arose before the end of transition. So we're dealing with EU law, not withdrawal agreement law. And just a few days after the Court of Appeal had issued this judgment, we got notification that the first tier Social Security Tribunal in Northern Ireland had made a preliminary reference in a parallel case, CG, to the CJEU. So we have this strange concatenation of circumstances where we've got these parallel bits of litigation going to particularly important courts. So we've got the CG going to the CJEU, and then Fritilla, permission to appeal was granted to the Supreme Court. And both were expedited, but the Supreme Court adjourned Fritilla to find out what the CJEU wants to say in CG. Spoiler alert, the CJEU basically ruined everything for Fritilla. The CG case, again, concerned facts during the transition period, so it was all about EU law. Again, the case was expedited on the grounds that the claimant's fundamental rights were at issue. We were dealing with a woman who had no resources, had a child, had escaped a domestically abusive situation, and I think was in dire financial circumstances. And because of her situation with a small child and having been relocated, did not have another right to reside upon which she could rely, but she did have pre-settled status. Now, the AG's opinion did come out pretty much in favour of the claimant, but sounded a bit of a warning bell by the fact it took a very curious turn in the reasoning. So rather than following Triani, rather than following the reasoning that had been argued by the claimants or was argued in Fritilla, found that she fell within the scope of Article 24 of the directive, and then went to argue that the conditions ought to be interpreted with regard to proportionality, and proportionality ought to take account of certain factors, including the rights of the child, which in its way was relatively promising and came out in favour of the claimant. However, the court basically took the first bit of that and abandoned the rest. So what we had was the court also saying, yeah, what we need to do is look at Article 24 of the directive. Why? She was not exercising a right under the directive. She was not claiming to exercise a right under the directive. But what they said was anyone who moves between member states and claims a benefit by virtue of that falls within the scope of Article 24. And therefore, we don't need to look at Article 18 TFEU, and we don't need to look at Triani. I mean, the problem here is that it stands in stark contrast with its previous case law, and also with Crayfeld. Remembering that in Crayfeld, the court had found that if someone had a right to reside that was not based on the directive, that right could not be subjected to the conditions of the directive. We have, quite a good analogy here, and yet that analogy was not examined. So my biggest question was, where did the primary law go? In Crayfeld, we had a reference to Directive 2004/38, where the court said that the directive, or Article 24, was merely a specific expression of Article 18 rights, which is a way of diminishing it. It's a way of the fact of the word merely, and the fact of the indefinite article. It suggests that there are more specific expressions possible, and what's more, there is a more important foundational right. What we have in CG is the court saying Article 18 is given specific expression in Article 24. That gives it's a tiny semantic difference, and yet creates a whole different framework that's being suggested. What we have is the idea that it is supplanted, that it is completely expressed in Article 24. Even though later on in the judgment, the court acknowledges that the claimant's right to reside cannot be regarded in any way as based on the Citizens' Right Directive. It's a sort of perplexing, convoluted and incoherent bit of reasoning, which I definitely take issue with, not least because the rationale is so poorly explained. There is one mention of Triani in the introduction or the background of the fact, it says that the claimant relies upon Triani and then never mentions it again, never discusses those arguments that were made, even though those arguments were prominent in the claimant's submissions to the court. And there is no mention at all, not even a passing mention, of the high-profile Fratilla case, which dealt with exactly the same question, which was heard before the Court of Appeal. The Court of Appeal's judgment was placed before them. Arguments based upon the Court of Appeal's judgment were placed before them, and that, you know, was pending before the Supreme Court. No mention. Which leaves us with the question of, is Triani overruled? I mean, are we to just see that there is a generic right to discriminate that emerges from Darno, and Article 2004, Directive 2004/38 rules over us all regardless? Well, the answer here is, again, slightly complicated. It's sort of no, but yes, that on its face, the reasoning is just not compatible with Triani. But the fact that it doesn't mention that case, the fact that it sort of skirts the Article 18 question, implying that there might be some situations in which Article 18 has purchase, suggests that it's all still left open. But that begs the question of when. When would Article 18 rights, the right to equal treatment qua citizen, actually help anyone if it doesn't help them when they move between member states? If moving between member states is what triggers your coverage by the directive. And so what we're seeing is the potential huge dilution of what is or was a fundamental right intertwined with EU citizenship, suddenly turning into some sort of a derisory leftover scrap of a right that might be used in some really unusual and esoteric situations. And of course, there is no mention of the ratio of Crefeld in this case. Again, a case on which the claimants relied. The court mentions Crefeld twice, but only to support the argument that universal credit is a form of social assistance, and the argument that if the rights of Article 18 are given more specific expression somewhere, then it's the more specific expression that takes precedence. But they don't engage at all with what they said about if a right arises outside of the directive, it's not subject to the directive's conditions. So we see primary law potentially evaporating. That rather begs the question, do we now face a generic right to discriminate against EU nationals based on Darno, given that this ruling is not just specific to the curious, esoteric Brexit situation of the UK, it's dealing with how EU law was applying at the time in a state that was effectively a member state. Well, what has happened to the need to interpret legislative restrictions narrowly, as outlined in Crefeld? If restrictions that are actually in legislation, derogations that are in legislation must be interpreted narrowly, why does a somewhat vague, generic entitlement to derogate from equal treatment, which is divined from the court's own intuition, have such an expansive reach? And part of what the court was relying on was the case that I've listed there, I don't know how to pronounce it, Bielkowski and Sheha, in which the court had found that where a state had adopted more favourable provisions to those in the directive with regard to acquiring a right to reside, it was up to them to decide what the legal consequences of that right to reside were in the context of permanent residence. So in the context of permanent residence, that is a right that only existed in EU law in the directive. It is entirely unsurprising that member states were allowed to require individuals to conform with the conditions of the directive to get permanent residence. As the AG pointed out in the opinion in CG, this is a different case, and the logic does not really apply when you're dealing with equal treatment where the rights are based elsewhere in a primary law right. And also, just as a matter of logic, member states cannot have free reign over the legal consequences of a right to reside that they create. I mean, they can decide all sorts of consequences. You could be entitled to a letter from the Queen or free juggling lessons or whatever it is. But those rights must be awarded in conformity with the general principles of EU law, including non-discrimination. If you just think about it for a moment, of course, member states can't be just free to discriminate at will because they've chosen to adopt more favourable provisions with regard to a right to reside. If you think about it and any other protected characteristic, it would be completely slammed down by the CJEU. And if we contrast this case with the approach that was taken in SOCU, whereby the restrictions or the permitted restrictions on access to employment in the public services did not extend to being allowed to discriminate once you'd let someone in. You know, the same kind of logic applies here, that the UK could have implemented right to reside conditions on getting EUSS. The withdrawal agreement allowed it to do that, but it chose not to do that. And so it has let them in and therefore cannot just discriminate against them on the basis that it could have discriminated earlier and chose not to. And what we see also is an abandonment of the idea of proportionality, because what we see here is an idea that these people with pre-settled status simply are not entitled to protection from discrimination. So there is no discussion about whether it's direct or indirect discrimination. There's no discussion of justification. There is no discussion of proportionality, because there is no need, because there is no right to equal treatment at all, which is deeply problematic. But also it means that proportionality is abandoned even where it should be considered a general principle of EU law. So not just in context of discrimination justification, but in the context of derogations. The Egenberger case, in the Egenberger case, the court found that proportionality was a general principle of EU law that should be incorporated even when it's not written into a derogation. And if the court had thought for any moment about proportionality, it would have been faced with a series of issues. It could not have avoided the fact that we're dealing with potentially very serious disadvantages, because unlike situations where people are in an EU member state, if they just go to their home member state for a period while they need to rely on social assistance and then come back again, they can't do that in this situation. If they leave and they break their continuity of residence, chances are they're jeopardising their rights to return, and they may never get settled status as a consequence. So we're dealing with very serious disadvantages. The fact that this rule cannot have any effect on purported benefit tourism, because we're dealing with a sort of retrospective set of facts. We're dealing with people who fulfilled the conditions for settled or pre-settled status, or for pre-settled status, which means they had to have been in the UK before the end of transition. They can't now think, this is a good way to get benefits, I'll just pop into my time machine. So it's not going to affect people's decisions in that way. The fact that people who have pre-settled status are on a pathway to settled status means that over time, the numbers are reducing already, the people who do have pre-settled status. And the fact that there is a time limit on pre-settled status, and the fact that we're dealing with a minority of minority of minority. These are people who have pre-settled status rather than settled status, who don't have another right to reside upon which to rely, and who also have a temporary need for benefits. So all those things would have to factor into a proportionality assessment, as would the total absence of any evidence produced by the UK that there were risks to the balance of the social security system. Whereas in other cases, like Commission and Cyprus, the court has actually taken a hard line on member states being able to produce with solid and consistent data that there are genuine risks to the balance of the social security system. What we saw as a sort of a fallback was a kind of a mopping up rights provided by the Charter. So people with pre-settled status were deemed to fall within the scope of EU law. In awarding pre-settled status, the UK was implementing EU law, unlike member states in Dano, etc. Now, I've argued that this is a not terribly convincing distinction, because member states who tolerate economically inactive EU nationals without awarding them benefits are also effectively recognising their Article 21 rights, TFE rights, by not deporting them, or not removing them rather. So this distinction doesn't necessarily hold up as to why the Charter is important here and not there. The court also makes a reference to such a situation as the claimant. But what does that mean? That other people need to conform to that exact pattern of facts in order to invoke the Charter? Do they need to show that they were victims of domestic abuse? What about if they have other sources of vulnerability relating to disability or chronic illness, for example? We don't know exactly how confined this application of the Charter would be. And not only do we not know when it bites or why, we don't know what it actually means. What is the threshold for determining that someone's charter rights are at risk? So what the court had found was that while she was not entitled to any protection from discrimination, she could invoke the Charter and her rights to family life, and in particular the right to the best interests of the child to be considered, in order to have the authorities decide whether her fundamental rights were at risk before they refused the benefit. Now, it's also worth noting here that it's a curious resolution of a case in a context where we're dealing with a country that's a huge Charter skeptic, evidenced by all sorts of things, including the Protocol 30 that the UK and Poland insisted be introduced to show that the Charter could not create new rights, including the UK Parliament's decision not to retain the Charter as part of retained EU law, and also just the UK court's ambiguous and often slightly tense relationship when it comes to, with fundamental rights legislation. So what are the implications of this case, of the CG case? Well, there's implications for the Fratilla case. Obviously, it's the Supreme Court can't uphold the Court of Appeals ruling now. It'll be interesting to see whether or not the Supreme Court can make a decision on fundamental rights, but the chances are it won't, because that was not argued before the previous courts. And the Supreme Court is not supposed to countenance new legal arguments. And moreover, it's not a fact-finding court. And in order to make fundamental rights arguments, you'd have to adduce these facts. And so this is a problem, an interesting sort of jurisdictional problem that's created when the CJEU chooses to answer different questions to the one that was put to it. When it comes to other pre-2021 cases, we're dealing with a situation that's very similar to other countries in the EU. So the implications are going to be echoed around, which are the question of when the CFR, the Charter of Fundamental Rights, bites, whose decision it is as to whether fundamental rights are at risk. Is it the decision of the benefit awarding authority, or can it be punted back to local authorities? And what threshold of resources is necessary to show that fundamental rights are not at risk? And when it comes to post-transition cases, there's going to be a huge, complex argument ahead, I predict, with regard to how we interpret the withdrawal agreement, because the Charter's role is vague, it's ambiguous, it's incorporated in union law, in the definition of union law, and the methods and principles of EU law and EU case law are supposed to inform the understanding of union law according to the withdrawal agreement. So it kind of percolates back into UK law through the withdrawal agreement. And of course, the agreement has direct effect, thanks to its own provisions, but also thanks to the EU Withdrawal Agreement Act. Now, this bit, I think I'm just going to briefly skip, just to note that the question that is being posed already and is likely to be posed in the context of withdrawal agreement reliance post-transition cases is whether or not pre-settled status is equivalent to temporary status in the withdrawal agreement. And my big question is, if it's not, what is? Oops. And finally, to conclude, the risk of administrative confusion and barriers shouldn't be overlooked here. That while we're dealing with such a complex series of cases, of facts, of rules, of decision maker guidance coming out, that what we're facing in reality at the coalface is reflex refusals. It's decision makers thinking, no, you're not entitled to anything, and garbled interpretations of the law, and of course a very selective approach to case law, because let's face it, the court itself is taking a very selective approach to its own case law. And the risk that I'm arguing here that's evident in CG is if we take in combination this problematic reliance and vague reliance upon the Charter with the aversion to Article 18 TFEU, what we end up with is quite a personalised judgment, one that feels like the court wants this claimant to get her benefits, but not many others. And that is a political intuition. That is not a legal principle. And that is deeply problematic. And in avoiding sound legal principle, the court has risked eviscerating Article 18 TFEU for pretty much everybody else. It's an area that's in desperate need of clarity. We have these intertwined, messy cases, all contradicting each other. And instead of getting that clarity, what the court has served up is a kind of a mangled, confusing and damaging judgment, which, let's face it, it's kind of Brexit themed in that respect. Thank you very much.
Oh my word. There is so much in that, Charlotte. That was amazing, really amazing. Very, very interesting indeed. So we can take questions. I think we have two options. One is you can either post something in the Q&A or you can raise your hand and I will attempt to bring you in. Let me just kind of maybe kick off with two things just from maybe the latter parts of what you said. One is on that question about guidance. How much guidance is there out there and how often is it being updated? And do you get a sense of, again, how that is being used? Are there, you know, what is very interesting about your talk is from a legal perspective, this kind of this normative shifting between different sources. But of course, government departments can do that as well in terms of what they use guidance for. Do you get a sense of how that might be translated into guidance? And secondly, just in terms of the Supreme Court, what do you think its options are, really, in terms of what it can do, what it should do, what it may be unlikely to do? Some of those kind of questions.
Yeah, so the question of guidance, there is both too much and too little. It's issued in huge quantities and relatively frequently, but also at the same time often not addressing key points, especially when it comes to EOSS stuff. And it's often of at best ropey accuracy. So, for example, the decision maker guidance that's been issued on how to respond to the Fratilla ruling in the Court of Appeal states that this judgment is only relevant up to the end of transition. And therefore, the regulations should just be applied as normal for any applications made in 2021 onwards, which is actually nonsense. That the DWP does not have the power to unquash quashed regulation. Moreover, it does not have the power to do it by dint of decision maker guidance. You know, the Court of Appeal did not. It's a moot question as to whether it even could. It did not issue a time-limited quashing. Either the regulations are quashed or they're not, and they're quashed. Admittedly, that ruling is stayed until we have the Supreme Court judgment. But the fact that this guidance is issued, which mangles the law, but is effectively treated as law by decision makers. I mean, in a case in a previous project, quote that will always stay with me when I was trying to argue a point with a decision maker, she said, well, we don't look at the law. just the guidance, and that sort of elevates the guidance to supplant the law in effect. And so the fact that you've got this guidance with these inaccuracies is problematic. I mean, as to dealing with how to respond to fertility, it's all become a little bit academic anyway because of what's going to happen with the Supreme Court. And to lead into your second question, what are its choices? I mean, it has very relatively limited choices. It seems impossible for it to follow the Court of Appeal in light of CG, because it's dealing with exactly the same questions. To find that Triani means that people with pre-settled status have a sufficient right to reside would be a complete contradiction of what the CJEU has just said. However, as I was hinting at, attempting to apply what the CJEU has said is also going to be problematic for the Supreme Court. So it's entirely possible that what it will say is the Court of Justice has decided that these regulations do not contravene equal treatment rules, therefore they just stay intact, and they may decide that without even a hearing, because any other arguments about the Charter were not made. And it doesn't have, it's not supposed to hear these new arguments. It's not the fact-finding court, which will put claimants and advisors in a situation where we basically need another case in which the Charter points are argued from the start to cycle all the way up through the courts. And that could really delay things in terms of thrashing out exactly what the reliance on the Charter entails.
Super interesting. I mean, because you've seen this so much at the coalface in terms of giving advice, etc. What's your sense of how many of these, how easy it is for these cases to get into courts in the first place? Because of course that is often the biggest hurdle. We can raise these questions as difficult ones, but unless you've got somebody who's actually going to bring this and can bring this, what's your sense of the ability to access courts in the first place to bring this kind of these questions?
Well, it's not easy.
Yeah.
At the moment, what's happening is that people are being refused benefits straight off, and they can appeal, but then their appeal will be stayed. Of course, a lot of people will get the refusal and just leave it at that. They might not know how to appeal. They might not know they have an entitlement to appeal. They probably don't know about the background of litigation that's going on that makes it worthwhile appealing to have their case stayed. In terms of making Charter arguments, this is where the whose responsibility to do the assessment question becomes quite pertinent, because there is a risk, given that the court says the authorities can take account of other resources available when deciding whether someone's fundamental rights are at risk. There's a risk that DWP will simply refuse benefits on the grounds that it's up to local authorities to make fundamental rights decisions, to decide someone's rights are at risk or not, and therefore apply the Care Act or the Children Act. And Section 17 under the Children Act is, it really is a last-ditch attempt at getting anything, and you don't get very much even if you succeed. But if that is treated as a local authority decision, then what you're talking about is judicially reviewing the local authority. And judicial review is it's incredibly complicated, it's expensive, there's huge barriers to doing that, which is why I'm arguing that actually it's the DWP's decision, because the CG case says, the judgment says, that they must ascertain fundamental rights are not at risk before refusing. That fundamental rights decision is part or anterior to the refusal. And so it's DWP who ought to be accountable for it.
Right.
The problem is people aren't going to realise that their fundamental rights are at risk until they have tried to apply for local authority support. And so we're dealing with,
I see that. So I've got some questions coming in. So first of all, Emily Hancock has got a question. So Emily, I'm actually going to allow you to talk, because if you want to actually ask your question, go ahead. If you're still there. Sorry,
I actually didn't mean to put my hand up, which is incredibly embarrassing. This is now going to be recorded for posterity's sake. But Charlotte, I'm actually a massive fan of your writing, and I do have a question, and it kind of comes from, I suppose, something which is my own research interest, which I suppose is this interrelationship between the different sources of EU law. And one of the things that you've been saying throughout this presentation is sort of, and I suppose more in the EU side, but is this point about, well, primary law is gone and what's happened to primary law. And so I kind of wondered if you had any thoughts about how to manage this, I suppose, slight tension, or more than a slight tension as it comes through in the case law of the Court of Justice, between, I suppose, the directive and, you know, with some other measures as well, and these primary law rights. I'd be really interested to hear your thoughts. Thank you.
Thanks very much, Emily. Sorry to unmute you if you didn't want to be. Before you answer that, I've also got another quick question. There's a very specific one as well. We can maybe take it at the same time, which is, you know, the questions raised is, does the departure of somebody like Advocate General Sharpston, who had very strong views on some of this stuff, does that take away a voice from the court that may make some of this feel a little less coherent as well? So a question round about that. And then I'll come to the other two questions in a moment.
To respond to Emily, thank you for articulating the tension. I honestly don't know what the appropriate response is, other than to do the legal academic thing of going and to make it clear that I think there are problems, and that the court has dodged the problems that it itself has created, and to continue to put forward too. So, you know, I do work with the Child Poverty Action Group, and have done some work with or liaised with the Law Centre in Northern Ireland, who were supporting the claimant in CG. So just continuing to put forward the various different arguments in order that they continue to get heard. I mean, it can feel a bit like arguing with a wall of bricks, but I think it's important, while those arguments are still possible to make them. And as I say, it's not entirely, it feels like the court's kicked over the traces of EU citizenship in CG, but it hasn't entirely, because it has, through, I don't know, intellectual cowardice, failed to acknowledge that that's what it's doing. There is still this potential for Article 18 rights to be made, arguments to be made. And so, yeah, it's just about keeping on making the arguments, I think. And as for, it all depends on whether there will be a sea change or not in the constitution of the court. And that will also relate to Kenneth's question about the departure of AG Sharpston. I think it is a significant loss from the point of view of having a really clear and coherent voice on these matters. But there have been quite a few advocates general who have also, you know, done their bit to attempt to reignite the light of EU citizenship, with AG Sargasmond, I don't know how to pronounce the name, in the A case, and AG Vasley. So there are, you know, some receptive voices or receptive judges still there, but it's difficult to. You have to remember that none of these trends last
Yeah. I've got a couple of questions, so I'm going to bring Monique Hawkins in to ask her question directly. And there's also a question from Claire Bradley, which is really a question about if the UK is going to start restricting rights here, what's the likely kind of retaliation or reciprocity we might see in other member states? And do you have any evidence of things happening with how British citizens have been treated in other EU states as a consequence? So Monique, if you are there, can you go ahead and ask your question?
Yes, thank you very much. Yeah, Charlotte, you were talking about how there could potentially be another case that was sort of looking at the charter and stuff. But I also wanted to know, do you think there's likely to be a case or an argument that's based on this, what was on your penultimate slide of the pre-settled status being an Article 13 WA statement, says given that otherwise the EU settlement scheme just doesn't implement Article 18.1, which is hugely problematic in itself? Like, what are they going to do? Just rerun the whole scheme? Or
Thanks very much, Monique.
Right, so yeah, great question about the slide I rather skipped over. Yeah, so I imagine that there is going to, being the pessimist I am, that there will be a dispute over personal scope questions. So given that post-transition, people are going to have to rely upon the withdrawal agreement, there will be questions of what is the personal scope of the withdrawal agreement. And the withdrawal agreement has different conditions to the EU SS. But are we really going to have a situation where the UK government is arguing that the EU SS does not map on to the withdrawal agreement? It creates a separate stream of domestic rights, so that there is a complicated Venn diagram where some people with EU SS status are covered by the withdrawal agreement and others aren't. I mean, that then opens up a host of questions. First of all, how are they supposed to distinguish between those that are Article 13 compliant and those that aren't? And do they have different routes of redress as well as different kinds of rights? But primarily, as you say, Article 18, the whole ground for making the scheme constitutive was the UK was exercising its prerogative under Article 18. If an Article 18 allows them to create a constitutive status that confers the rights in that part, pre-settled status does not confer the rights, then on what grounds, on what legal basis did the government make the EU SS constitutive? Did it make it mandatory to register by a deadline? Because it's not Article 18 if it does not confer the rights in that title. So there's that question, and then the flip side is, well, if it doesn't confer the rights, what does? And the fact that they haven't, we are post-transition now, we are post-Brexit, and it hasn't created some equivalent status. I mean, I think there's a very strong argument to be made that it has to be treated, pre-settled status has to be treated as Article 13 status, and people with it have to be treated as though they meet the conditions of Article 13. I'm sorry, what was
thanks very much.
You outlined a question from Claire Bradley.
There was a question about are we likely to see issues in other member states as a consequence of what may be seen as a restriction of rights of EU citizens in the UK? So is there something going to happen to British citizens? And Catherine Barnard has posted something in the chat. So are you seeing also questions around pre-settled status and access to healthcare? Is that coming up as something? So we're kind of short on time. So if you can give us your elevator pitch answer on those ones, that would be appreciated.
Well, the answer to the first question is very straightforward, which is I don't know. I don't know what is happening with other member states and Article 13 status, effectively, or what their equivalent of Article 13 status is with UK nationals. But there are people like Michaela Benson at Lancaster who are working specifically on Brexpats, UK nationals in the EU. And on the, did Dano not put a knife in Triani? Well, the key argument of the claimants, which was accepted in the Court of Appeal, was that it hadn't put a knife in Triani because the circumstances were different. Dano, you were dealing with someone who was relying purely on Directive 2004/38 to establish a right to reside. In order to rely upon the directive, they had to meet the conditions of the directive. Triani, you're dealing with someone who has a pre-existing right to reside that's not dependent on the directive. And that's where the claimants argued the analogy was, rather than with Dano. And with pre-settled status and access to healthcare, we have had some evidence that some EU nationals are facing some difficulties. I don't think I'll go into any more detail at this stage because it will just take too long.
Great, thank you so much, Charlotte. There is, as I said, there is so much in this. It's absolutely fascinating, very complex. But your talk really illuminated so much of that for many of us, both in terms of the very specific issues round about pre-settled status, but also just that more general landscape of where the court is going in its continual shifting of its feet between primary and secondary sources, which is a perennial issue, it seems, at the moment. So it just leaves me to just say thank you so much. Lots of comments from people saying how brilliant the talk was and how much they want to delve back into the slides for more of the same. So thank you so much, and thanks to everybody who joined in and participated today in one form or another. So thanks very much indeed.
Thank you.